Welcome. We want to thank again the Cummings Foundation and Bill Cummings for allowing us to put on another seminar with respect to business and law. They paid for your lunch, so you should be dinner. You should be thanking them as well. We have a great presentation tonight. We've got a lot of great speakers with respect to the issues that I think you're going to find compelling. I want to thank you all for coming, and I'm going to turn it over to Professor Devlin so that he can start with when employees go rogue. Interesting topic for him.
Good afternoon. I don't know very many of you. Dave, why are you late? Victoria, how's your mom?
Oh, she's good.
Good. Glad to hear that. Jonathan, did you see that Lee came in? Okay. But I don't really know any of you. So I understand you had, some of you anyway, had a professor who might have taught you a few things. Well, he didn't come close to teaching everything you need to know. So that's why I'm here. Okay? What's going to happen is your employees, whether you are own a law firm or whether you just work as a solo practitioner, and you have business clients, corporations, limited liability partnerships, limited partnerships, LLCs, who cares? They're going to have employees, and those employees are going to go rogue. And your job as an attorney is to minimize the risk that your clients or you, as the owner of that law firm, are going to have. So, and we're not just talking financial liability, we're talking criminal liability. So we got to be careful out there. Now, in a recent study, it was shown that almost 70% of employees out there had bypassed their company's policies and procedures manual. Their security policies in the last year. 75% of them said, I'd do it to get further in the job. It's a new era. It's a different era. We don't have, some of you older people, and I guess, what the hell? I'm referring to the dean. I think we're about even. The older, we had this buy-in. That's what we were taught. But I've got kids, and I taught them incorrectly. I taught them to be themselves first, and so they are themselves first. They're wonderful people, and they're professionals. But if you want to give them a, $10,000 raise, they're gone, and they will go to you. Loyalty is not what I grew up with, and that's fine. Maybe we were taught incorrectly. I'm not making a value judgment, but it is a different era. And we've got this problem tonight of moral disengagement, which is just, I apologize, Professor Lamy. To me, it's psychobabble. Moral disengagement is nothing more than you justifying your bad actions. Because it wasn't me, it was me doing it for a reason. I don't get it. You've heard it, you might have even said it. Everyone else is doing it, so why can't I? Or, it's not gonna hurt anybody. Or they don't pay me enough. Or I'll pay it back first chance I get. I've probably said all four of those in a week, and not just once. It's the way the world works. So, or you're about to learn, under respondeat superior, it's a theory, it's a concept, that if an employee of yours is negligent in the scope of their occupation, we learn it, I teach it as SOTO, so you remember, scope of their occupation, if they're negligent, then the employer, your client, you, if you're the owner of that firm, are liable, financially liable. And you didn't do anything wrong, but it's something known as, it's a policy choice, it's something known as vicarious liability. Now, plaintiff's attorneys, they call you or your client firms, they call them the deep pockets because they're the ones with the money. And it's your job to prevent that money from going to those plaintiff's attorneys. And there are ways to do it. We'll get to that. There's really, it's it's the United States in one concept, in one form or another. This is the law in the United States. There is no getting around it. Do not try and call or have your clients call their employees independent contractors. Therefore, they're not employees. It's not going to work. Okay, trust me, I've been burned on it. It's not going to work. So given the previous study that I mentioned, any employee with a computer, and that would be every one of your employees or every one of your clients' employees, has the potential to do a significant amount of mischief and cause significant financial damage to their employer. This is a typical employee. His name is Chad. And I was talking to him earlier today. I said, dude, why don't you come over later on today and we'll play Dungeons and Dragons and we'll do battle in my mom's basement. And I said, what time, Chad? So that's him. Now remember, we're talking about people and their computers. Let me give you some examples of what can go wrong. The first is copyright infringement. Employees are installing and using copyrighted protected software at work to share music, videos, other software on the clock for purposes related to their job duties. That's SOTO, scope of their occupation. You're liable for it. Your clients are going to be liable for that. So be careful. Well, okay, it's unrelated to their job duties, so therefore it's photo, it's frolic on their own, so respondeat superior doesn't apply, I'm free to go now. Yeah, we'll get back to that. Defamation, employees using company email to email other company employees or elsewhere with defamatory remarks. It happens all the time. It happens too frequently. And if the subject matter of the emails falls within an employee's job description, you, as the owner of that law firm, or your clients, as the owner of their businesses, are going to be liable. Okay, so what about trade secrets? Well, there's a definition of trade secret, which couldn't be any broader if they tried. Meaning, if your employees or your clients' employees use trade secrets that are not theirs to use, you're going to be on the hook. You're going to. That's all you need. It's that much of a minimum. And speaking of secrets, the Colonel, 27 herbs and spices. It's a secret recipe. I've spent the last 4 months, putting 24 of those spices into those bags you are eating. I can't figure out the other 3 spices. I'll get there. So I hope you're no longer hungry. Your employees, your clients' employees, better not use other companies' trade secrets. Oh, you're going to be in litigation hell. So don't do it. Don't let them do it. And make sure that your current employees don't use your trade secrets when they leave, because they will leave, because someone offered them another $3,000 a year. They will leave. Massachusetts passed the Uniform Trade Secrets Act, and it's known as the Massachusetts Uniform Trade Secrets Act. That's great, Massachusetts. Really proud of you. You realize you were the 49th state to do it. Alabama, Mississippi passed this law before you got around to it. You should be ashamed of yourself. So every large and not so large entity out there, employer out there, has its own policies and procedures manual. You might have even gotten a copy when you were hired. Great. All too frequently, the document is either thrown away, it's filed away in a storage cabinet, or it's so deep in the cloud, it's ignored. It is. And the example for tonight was that business case from the Harvard Business School, Chris and Allison Weston. How is an employee able to embezzle over years over $1 million? What the hell's going on here? Well, I've already talked about the lack of employee buy-in. You know that. There's a lack of employee oversight, but you know what? You know where we are? We are in the best country ever invented. Probably ever will be invented. And it was founded on the principle of checks and balances. It was, because human nature is human nature. So with regard to those checks and balances, let me give an example before we get to your underpaid associate. In the old days, you young people won't understand this, they were treasurers of companies, and they actually wrote checks. That's it, checks. I know. Not checks and balances, checks. And back in the old days, my grandfather told me this, I never knew this. The one smart thing to do was to require two signatories on that check. One is the treasurer, of course, who has the ability to sign checks, and the other is somebody else. Now, granted, that's not the best level of security, but at least not only are they going to have to embezzle, but they're going to have to forge, so they're going to jail. It's just another level. That's what used to be done. But we're checkless. We're cashless. So we need something else in this day and age. And this is either you or when you were an underpaid, underappreciated, overworked associate attorney. And you know what you do when you become partner in the firm? You give it right back. And so now that you're the partner in the firm, this is your underpaid associate. And you know what that underpaid associate's going to do? That underpaid associate, AI, that's it. It's so damn, do you know everything ever is now on AI? Awesome. So all you need to do is press the button. So Stephen Schwartz, Esquire, pressed the button. He needed to do some legal research for a brief that he was filing in New York, in court. And he did. The cases that were cited for him, the cases that he used, were non-existent. AI, check it out, can hallucinate. And it did. Unfortunately, Stephen Schwartz is no longer Stephen Schwartz, Esquire. Are you getting the message? Well, Massachusetts has its own ethical rules. Massachusetts Rule of Professional Conduct, Comment 8. Attorneys are required to keep abreast of changes in the law. No duh. But then, including the benefits and risks associated with relevant technology. I read that and I went, I'm supposed to be an expert, and I better hire somebody who is, because you're going to need to. Give you another example. You might have heard of this new company called Facebook. Yeah, that's it. Facebook. This guy, Attorney Smith, he decided to do a little humble brag because he worked on this case and it was complicated and it was somewhat sensitive, and he worked on the case and he decided to go on Facebook and delete all the names and humble brag about the awesome result he got. Not bad. Good for you. Except someone took the time, it wasn't that difficult, to dig a little deeper, and they were able to figure out who the client was, and now all of that client information, that confidential information, is attached to that person. It's public, and that is a violation of Rule 1.6, confidentiality, folks. He's still an attorney, but, he got spanked. So you've got to be careful out there. And you've got to have your associates be careful. And you've got to have your clients' employees be extra careful. So one last example is harassment. You might have a bad actor employee using a company computer to harass others. Sexually explicit messages, graphic images to coworkers, that is harassment. And you really need to wake up and do something about it, because you're going to be liable. Now, the good news is, well, yeah, but I told them no sexually explicit images. Therefore, it's not within the scope of their job duties. Therefore, it's on a frolic on their own. Therefore, respondeat superior does not apply. Therefore, I'm not vicariously liable. Yeah, turn the page, will you? Because what you are going to be liable for is your own negligence. If the employer knows or should know that shenanigans are going on, if the employer knows or should know that employees are using company computers to do bad things and doesn't do anything about it, then that's negligence. You can call it negligent supervision. You can call it negligent retention. You can call it negligent hiring. Because, let's face it, you remember Chad, how much background, and there's tons to be able to be done, how much background did you do, a check on him before you hired him? So look, with regard to you as attorneys, with regard to you representing clients, and you're gonna You know what you're going to do? You're going to be asked, we need a policies and procedures manual. You got any? And the answer is, of course you do. AI is a, no, I didn't say that. That was a joke. Solution number one is draft, circulate, and implement a comprehensive company workplace technology policy. Limit access to confidential information on a need-to-know basis. There'll be fewer people who resign and use your trade secrets against you. Conduct detailed interviews with new employees so they know what they are forbidden from doing. Make it photo. Forbid the downloading and dissemination of pornography and copyrighted material. Forbid the posting of discriminatory, harassing, or defamatory emails. Forbid the downloading of unauthorized software. That's a nice manual you got there. And then, uniformly and consistently adhere to and enforce those policies. Have somebody, monthly, I'd go weekly, check everything. Check the ledgers, check the finances. Every week, someone who's not got a vested interest in that can't write a check to themselves. Have them check. Chris and Alice and Weston wouldn't have gotten away with what they got away with if there was somebody doing something basic, checking. Amit Patel got away with $22 million. There was no oversight. You need oversight. You need checks and balances. So if you do that, one last thing, and that is, I already told you, you're going to have employees who resign. Sit them down. Tell them, here's what you've known. Here's what you've learned. Everything that they have learned. They are trade secrets. Don't you dare use them. Because think about it. I'm making your job easy. When this ne'er-do-well actually does use those trade secrets, it's a slam dunk. It's a summary judgment case. Did you get that document? Did you sign that document? Did you agree not to? See how easy this is sometimes. So I thank you for listening. I hope you like the food that I prepared. If you have any questions, not right now. We've got work to do. You know how to get to me, okay? Thank you, folks.